good to see you guys. Oh, and then there's the CEO of the paw firm, right on cue. Stop it. Stop it. It is not. No. I'm on time tonight. It barely said that that was showtime. Fractional time zones for the win. Hello, C-Rex, honey. Hello, sweet Linda Applegate. Hello, Buzzy Pug. Hello, Jerry Matthew Boyd. Oh, and by the way, hello, Ironworker Connie. Hello, Eileen Carlin. Hello, Charlie. Do you still giggle like a 12-year-old girl whenever I say your name? Oh my gosh, it's so good to have you guys all here. I actually have court tonight. I actually have court stuff. Yeah. I went deep in the archive drive and found some. Yes, I had to rely on the archive drive because court lately has just been uninspiring and just not exciting. Aww. Love having you here, Ironworker Kenny. Oh, Bandit. Hold on, guys. 1 second here. I have something that I have to do that I can only do. Oh, wait, you know what? I can do it up here. Oh. Okay. This was a gift from C-Rex. She Venmo'd me some money to be able to gift memberships to the chat. She wants treats, and she knows if she gives kisses, she gets treats. But now I've changed up the rules for the treats, and I want her to use the litter box to get the treats. I don't know. It's been so hard to find content lately. It's a real struggle for me. Trust me. I mean, I thought it was bad sitting here for 15 hours and, coming up with some really good stuff, but only enough to run one live. Well, now I can sit here for 15 hours and have nothing. Not even enough for a live. So, yeah, that's why I had to rely on the archive drive. That's why I have it. But I think you guys are going to enjoy tonight.
All right. Is there anyone else with an announcement? Your Honor, for Republic Finance versus Lolenta, we were not able to come to a settlement agreement, so we would like to proceed with trial. This is our second time on.
Okay, that's you all's motion for default.
Yes, sir, Your Honor.
Okay, so position one is a motion for default. So we're going to take that case next, Republic Finance versus Amadou Lolenta. So if you will both turn your screens on.
My screen is on, Your Honor.
All right, thank you. All right, who's testifying? Mr. Lolenta, are you testifying?
Yes,
All right, raise your right hand. Do you swear or affirm that the information you provide to this court will be the truth, whole truth, and nothing but the truth under pain and penalty of perjury?
I do.
All right. 1 second. All right.
Your Honor, back in 2019, I went
Well,
to.
hang on, Mr. Lolenta. Hang on 1 second. So, Mr. Cornelius, this is you all's case.
Yes, Your Honor.
So, go ahead and tell me what you are requesting.
Do you need me to be under oath as well, Your Honor? I'm pro se.
Hang on 1 second. You are, Mr. Cornelius, you're not an attorney, is that right?
Correct.
Okay. Did you all file a affidavit in this case?
Rule 31, yes, sir. I sent it to Miss Willis.
And Judge, it
Okay.
has been filed.
All right, thank you.
You're welcome.
All right, so yes, Mr. Cornelius, raise your right hand. Do you swear or affirm that you're going to provide the information you provide to this court will be the truth, whole truth, and nothing but the truth under pain and penalty of perjury?
Yes, Your Honor, I do.
All right, go ahead. Tell me about your case.
Your Honor, the defendant was sent
Well,
a.
I'm sorry. Back up 1 second, Mr. Cornelius. Tell me how you're associated with Republic.
I'm the branch manager of the location that originated the loan with the defendant.
Okay. Now, go ahead.
Okay. Mr. Lolenta took out a signature loan with Republic Finance. This was done on March 12th of 2019. It was a payment schedule of 36 payments of $310.
It appears he may have lost connectivity, Judge.
It appears that way. We're going to just hold on a second.
Sure. Sure.
We'll be in recess just for next couple minutes. We'll see if he reconnects, and then we'll go from there.
Thank you,
Sure.
Judge. Judge, Mr. Cornelius has returned.
All right, Mr. Cornelius, you will unmute yourself.
Sorry about that. I apologize. It dropped.
All right, go ahead. You were telling me that he took out a loan.
Yes, sir. It was a payment schedule of 36 payments of $310 per month, with the first payment being made on April 11th of 2019, expiration date of March of 2022. The defendant made payments until he became delinquent after the fourth payment or fifth payment as of September 11th of 2019. And at the time that the suit was filed, there were no payments made up until that point in December of 2019. He ended up making two payments of $325.50, a payment of $310, and then a payment of $635.50.
So, Mr. Cornelius, you can jump to tell me what the balance is.
Okay, so the balance that we had filed for was as of the date of whenever we had filed the suit. However, since then, the defendant did make payments on the loan. If you include the $105 for the private process server and the electronic filing costs, the remaining judgment balance was $6,061.19.
What was it? Your principal?
So the principal amount would be $6,061.19 minus the $54.816. So the principal balance would be $5,879.03.
Okay. Mr. Lolenta, now it's your turn to tell me what you want me to know. Let me just say this. This is a default hearing. You did not file an answer. Can you tell me why you didn't file an answer?
Your Honor, I was not even aware that this is possible. First of all, I remember somebody coming in over here, knocking my door, handing me a portfolio, and after that, COVID hit, and I
Okay.
have not received
No,
any.
all right, we'll stop right there. What do you have to say about is there anything that you have in regard to the damages that Mr. Cornelius is claiming?
Your Honor, I am aware that I did borrow the money I'm totally responsible for it. I made payments and they filed a lawsuit. I turn around and I start making payment. What I'm willing to do is I told Mr. Cornelius, it's fair. What I want to do is the amount of money that I borrowed from him, since he told me it was a simple interest loan, I say yes. Okay, since it's a simple
Well,
interest loan.
let me pause you. I don't know if you heard my announcement about what you all are willing to do and what you have agreed to do, whether he's accepted it or not. I just want to know, do you have anything in the way of damages that I should consider before I make a ruling?
The only damage that I have is I'll close my business in December 31st, and I'm willing to settle this case.
Okay. So here's what's going to happen, Mr. Lalenta. You did not answer the complaint, so you are in default. I considered this a damages hearing because technically that's what we're here for, to find out what Republic Finance had in damages. So legally, you've already admitted all of the facts in the claim by not answering. It's an operation of law.
I did answer. I was in court about 3 months ago.
All right.
I
I
came
don't
to
think you're,
county.
listen, Mr. Lalenta, you might need to talk with an attorney because you're not understanding the legal significance of not answering the complaint. Okay, that has consequences. When you're served with a complaint and you do not answer it, it has consequences.
I did answer.
Right. Okay. Do you have any questions for me, Mr. Lalenta?
No, I'm just trying to figure out when you said that I did not answer. I was in court the other day when I came to.
It doesn't, let me just explain. It doesn't work that way. If somebody serves you with a complaint, you have 30 days to file a written answer. That did not happen.
Yes, that did not happen.
Okay, so that's a failure to answer. I understand that you said you came to court, but technically that is not an answer. Okay, your answer had to have been filed within 30 days. You did not do that, so you are in default. I've heard from you, I've heard from Mr. Cornelius, and I'm going to find in favor of the plaintiff, so for Republic Finance. And you all can still talk and you can still work something out with them, but they're going to have a judgment against you in the amounts that they've pled and proven today. Okay? Now, the last thing is, if you disagree with my decision, you might want to talk with an attorney. Okay? Because I can't give you any advice. Typically, you would have 30 days to appeal, but this is a default hearing. All right? So that's going to conclude your hearing today. What questions do you have for me, Mr. Lalenta?
Your Honor, I do have a lot of questions. First of all, I did not know the severity. That's number one. Number two is, just like I said, this happened when I was served. That was during COVID.
You were served. That right there kind of tells you it's serious.
And he came back. I received another letter.
So I'm asking if you have any questions. I know you want to explain it to me, Mr. Lalenta, but I've got several cases on the calendar and you're not giving me a legal basis. I've got to follow the statute. You haven't given me a legal basis to do anything in your favor. All right.
I wish I would have done a little more homework. I wish I would have done. I thought this was going to be pretty easy. I thought it was going to be pretty easy. I thought I was just going to walk in and I was going to settle with him and he's going to accept it and I was going to go on my business and
I
look for
understand. You all can, let me just say, hopefully you got his information. You all are still welcome to settle the case.
He doesn't want to.
Okay. Well, that's an issue that you have to take up, that he does not have to settle it. So that's going to be my ruling. You all can get a copy of the order. It'll be available either later today or first thing in the morning. But the two of you, if you don't have anything else on this calendar, Mr. Cornelius, you all are excused.
Thank you, Your Honor.
All right. Thank you. All right.
Your Honor, we're probably going to see Mr. Brown next, but we have the Vietnamese interpreter for Mr. Lou. I believe we're going to see him over the iPad. I think they're going to bring the iPad down to him. But essentially, when we tried talking to him, he would talk over. I mean, the problem is he's talking about relevant information, but not allowing. Anytime myself or the interpreter tried to speak, he would talk over us, and there's nothing I could do to get him to not do that.
I have to take Ava out real quick. She's got to go potty. And I'm going to let this one run while I've got her out. But just so you know, yes, there is a Vietnamese interpreter. The defendant switches back and forth between English and Vietnamese. So definitely listen to him. He does have a very thick accent though, but it's so worth watching it anyways.
And so we couldn't get through any information for the arraignment, to the point where, I mean, I believe that the 1077 could be an issue, but I hesitate just because if there's anything that could change how he was behaving, I would rather not have him evaluated.
Okay.
But that's kind of what occurred. And the only reason I'm bringing this up right now is because we have the interpreter here. And so I just want to give the court a heads up.
All right, thank you.
And score, we could do Tat Lou first. Is that okay?
Sounds good. I'm on my way.
And then this is Mr. Lou.
And this is City versus Tat Lou 480319683, and we are assisted by a Vietnamese interpreter.
Cái này là cái vụ của bên thành phố đối tụng với Lưu Tốt, số hồ sơ là 4A0319683. Chúng ta có sự hỗ trợ của người thông dịch. For the record, Your Honor, James Nguyen, Washington State Certified Vietnamese Court Interpreter, the interpreter permanently song with the LC, Your Honor. Để ghi vô sơ thưa bà quan tòa, người thông dịch tên là James Nguyễn, có chứng chỉ của tòa đã được tuyên thệ cố định bởi văn phòng hành chánh quản lý tòa.
Mr. Liu, have you had a chance to speak with your attorney?
Yeah, okay.
Ông Lưu.
I have a question, but so why? I think I have, why have I go to jail?
I'm sorry, I can't hear you, sir. Can you come closer to the door?
Thì ông xin lỗi, tôi không có nghe ông nói, ông tới gần cái cửa nữa được không?
I can't hear you. Can you please come closer?
Tôi không có thể nghe ông nói với ông, làm ơn đến gần đừng chút nữa không? Lại gần chút nữa.
Ông nghe được mà.
I can hear.
Nghe được mà.
Yeah, I can hear you.
I can't hear you.
Nhưng mà tôi không nghe ông nói được.
What you say?
Did you have a chance to talk to your attorney?
Ông đã có cơ hội nói chuyện với luật sư của ông chưa?
Tôi làm gì? Tôi có luật sư. Tôi không có tiền ăn. Tôi có luật sư.
I don't need a lawyer. You know, I don't have a lawyer. I don't have any prior.
You do have a lawyer here to assist you with the arraignment, Mr. Ayanati.
With the
Thì
lawyer.
ở đây có luật sư giúp cho ông với phiên tòa thông báo tội danh của ông á. Ông luật sư của ông tên là Nadi.
Tôi biết, tôi không có tiền mướn luật sư á.
I know, but I don't have money to hire a lawyer.
You don't need to hire him. He's just here to help you.
Thì ông không có cần mướn ông ta ở đây, ông luật sư này ở đây giúp cho ông.
Tôi cần đi ra. Đi ra.
I need to get out. I need to get out.
Ông
I
có
don't want to sitting in here.
So I need you to work with Mr. Tat, please don't talk over me.
Ông tốt đừng có làm ơn đừng có nói chuyện khi mà tôi nói với ông, đừng có cắt ngang vô.
Ông cái nào ông nghe được ông mới nói, cái nào nghe không được ông đừng có nói. Ông thấy nghịch kỳ kỳ đấy, cái gì ông nói la ham luôn à. Ông phải ngưng lại chứ.
He sure is an angry little man.
I say I am don't have a problem something for the airport. I'm not still not bank or not empty. Why did we come here? Keep me go to jail. Why?
Well, you're charged with a crime, sir. So I need you to work with Mr. Ayanati so we can get through the arraignment.
I want to get out over here. Get out. Okay. Right now.
No, we're not going to get that far until you work with Mr. Ayanati.
What the fuck? What the fuck? No. I want to get out right now.
We all heard that one.
I understand that, sir. But that's not gonna happen until you work with Mr. Ayanati.
What the nani? What kind of nani? Talk about Vietnamese guy got leg with guy. What kind of nani?
Ông phải làm việc cho ông mà Nadi, ông luật sư đó rồi mới được thả.
Hả? Ông là luật sư nani hả?
Who's the lawyer?
What?
Who is the lawyer?
The man in the white shirt. Can you wave your hand, Mr. Ayanati?
I'm the attorney that spoke to you earlier.
Đó là cái người đàn ông áo trắng này.
I go to see the airport. Don't have a mind to go see the airport. Go have something. Go have a sleep the airport nữa. You
can't go to sleep in the airport.
Why?
Because it's against the rules.
No. I don't want to sleep the airport. I don't have a choice. I sleep the airport. No.
Mr. Tat, what? We're not going to discuss the facts of your case. I need you to talk to Mr. Ayanati and just understand your rights at arraignment.
What my wife?
Mr. Ayanati tried to go over that with you, and he said you kept talking over him. You have to listen. You have to work with him.
Go home. Give me out.
That's not Mr. Tat. Mr. Tat. That's not happening until you work with Mr. Ayanati.
I need a wife. I go home. Give me a date. Appointment. I go to court. Okay?
And I can try again, Your Honor. I can just
Okay.
read the rights and see if.
Give me a date. I go to court.
You're in court right now.
Okay?
And officer, I'm going to send another invitation for a breakout room so we can try that again.
Get out of here. Give me a date. Why don't you give me no?
And Your Honor, I was unsuccessful. I can try and read the rights again, but I can evaluate under 1077.
I don't want to see lawyer, liar. Okay.
Okay. It doesn't seem like we're getting anywhere.
What's up, you? Get out of here. I don't want to hear.
So then the issue is only in custody or out of custody. Officer, we're not quite done with that hearing yet. I'm sorry. Oh, now we are. Okay. All right. In custody or out of custody?
The city is requesting bail in the amount of 500 cash or bond given defendant's level of aggression, we just haven't been able to get any indication from him that he's going to cooperate or return for out of custody evaluation process or hearings.
Mr. Ainani?
I don't have any information to provide the court because I couldn't get that far. I mean, every time the court's heard everything that I just have this conversation and I haven't been able to. He keeps saying we'll go up for a court date though.
I'm gonna order it in custody. We'll see you back here on April 10th.
Chúng tôi sẽ gặp ông lại vào ngày 10 tháng 4.
$500.
The court already
Will be set
appointed.
at $500, and I
Tiền bảo lãnh là 500 đô.
I did find probable cause to detain yesterday.
It's so bad that the other inmates surrounding him are yelling at him to shut up.
I don't have money. You got no money. If you have money, you bail out. See, they got nothing, no banker, nothing to go jail.
Speedy trials hold.
Mình làm em tụi phát hả? Phát hả? Em thọc phát hả?
Okay, now we're done. Thank you, officer.
Hurry up! Let me get out. I'm not eating that.
And Officer Thomas, we're ready to go to the next.
And the court appointed.
Thank you. No, I didn't, but I will. And I didn't put the date on here too. A little off my game. Thank you, Mr. Nguyen. That's your only matter, right?
Yes, Your Honor. You are welcome, Your Honor.
Thank you very much. See you next time.
See you next time, Your Honor.
I'm assuming, I mean, Mr. Liu tended to resort back to English, but I'm assuming that we still need the interpreter to be on the safe side.
Yeah.
I tried to see if he wanted to just proceed without, but he didn't. We never couldn't complete that conversation either.
Okay.
Just gonna set it here.
I believe this is Miss Liu. Is that you, Miss Liu?
Yes.
Okay. This is you, Liu, 4A0239050. It's court ready.
Yes, go ahead.
This is a return on a 1077 evaluation. We have had a chance to review it. I don't have any objections to the court adopting its findings.
How about the city?
No objection.
I don't either, having reviewed that. So I'm finding that Ms. Liu is able to proceed.
And
who was the author? Who was the author of that report? You happen to know offhand?
you're wrong. Liberty,
Okay,
PhD.
thank you. And then how are we proceeding?
Ms. Liu is adamant that she wants to plead guilty to this charge. And so we are asking this court to accept a plea of guilty to 1 count of criminal trespass in the first degree. I will go over the collective.
Ms. Liu, you need to stop doing what you're doing and pay attention to court.
Okay.
Ms. Liu, earlier today, I went over a statement of defendant on plea of guilty with you. Did I read that document to you? Did you read it or did we read it together?
You read it. I listen.
Okay. And at the bottom of it, there's a place for you to sign and it's not signed. Have you not signed it because you don't have a way to sign it?
Yes.
Do you promise to sign it later?
Yes.
Do you understand? It says that you're, oh, I guess is your true and correct name Yu Liu?
Yes.
And you're 51 years old and have completed past the 12th grade.
Yes.
Do you understand that you're pleading guilty to 1 count of criminal trespass in the 1st degree?
Yes.
And do you understand what the city would need to prove in order to find you guilty if you were to proceed to trial on this case? Ms. Liu? Sorry, I just talked. Do you understand what the city would need to prove, what the elements of criminal trespass are?
Court do whatever they want.
Can you bend down, please, Ms. Liu? We can't hear you.
Court do whatever she thinks is right.
No, I'm asking if you understand what criminal trespassing is.
Yes.
Okay. And you understand that by pleading guilty that you're admitting that you were trespassing and giving up your right to go to trial?
Yes.
So you're giving up the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed?
Yes.
The right to remain silent before and during trial and the right to refuse to testify against yourself?
Plead guilty. Nothing else to say, just plead guilty.
I know, but we need to go through this, Ms. Liu, like I explained. You understand that you're giving up the right to remain silent during trial?
Yes.
You understand you're giving up the right to refuse to?
Else to say.
Ms. Liu, we will not be able to get through this if you won't answer the questions.
Yes.
You know, you are very familiar with this process because this is your 1, 2, 3, 4, 5, 6, 7, 8, 9th time pleading guilty.
No, you do the shame.
Okay, sorry, go ahead.
Do you understand that you're giving up the right to refuse to testify against yourself?
Yes.
Do you understand that you're giving up the right to hear and question the city's witnesses?
Yes.
You understand that you're giving up the right to call your own witnesses?
Yes.
You understand that you're giving up the right to be presumed innocent until the charge is proven beyond reasonable doubt? Ms. Liu?
Yes.
Do you understand that you're giving up the right to appeal a finding of guilt after trial?
Yes.
Do you understand this crime carries a maximum sentence of 364 days in jail and a $5,000 fine?
Yes.
You understand the city's made a recommendation, but the court doesn't have to follow it. The court can sentence you up to the maximum penalty?
Yes.
You understand the court can place you on probation for up to 2 years?
Yes.
You understand the court can order you to pay costs, fees, assessments, any restitution that's owing you? You understand that if you're not a citizen of the United States, a plea of guilty can have immigration consequences? Ms. Liu? Do you understand that if you're not a citizen of the United States, a plea of guilty can have immigration consequences?
Ms. Liu, are you okay?
Yes.
Okay. And did I discuss those consequences with you and answer how this plea would affect you as far as immigration is concerned?
Yes.
And Your Honor, I can represent that I believe I've satisfied my obligations under Sandoval Padilla. Has anyone threatened you to have you plead guilty to criminal trespass?
Ms. Liu, we can't hear you.
I answered his question.
I can't.
No, I said no.
What?
I said no. Is that
Okay.
right? Oh, you want me to answer? Yes.
I want you to answer with whatever your answer is. I can't hear you is the problem.
And so I'll ask that question one more time. Has anyone threatened you in any way to have you plead guilty?
No.
Has anyone promised you anything to have you plead guilty?
No.
And I wrote this statement, but you adopt this as your own statement that on February 18th, 2024 in SeaTac, Washington at the SeaTac Airport, Port of Seattle, you knowingly entered and remained in the airport without lawful authority to be there.
I told you in my words, I will say enter the airport without a ticket. Okay?
Ms. Liu, can you please bend down? It's very hard to hear you.
I said to the lawyer early that just right, enter the airport without a ticket. He did not listen.
It's not that he didn't listen, but that's not a crime. You have to, if you're pleading guilty, you have to admit to a crime.
In my words, that's what I say. If you say, or lawyer say, that's what you say.
So we've been over this, ma'am, we've been over this many times. I cannot accept a plea unless it alleges a crime. What you're saying is not a crime.
Whatever. That's my English.
You have done this 9 times, ma'am. This is not a shocker. You know how this goes.
And Ms. Lou, can I
That's
add that?
limited elementary school level English. Okay.
Can I add that you were previously ordered not to be at the airport? So Ms. Lou, did you hear that? Can I change it to you enter the airport without a ticket and after previously being ordered not to be at the airport?
That's my English. Okay. Enter the airport without ticket. That's my
I know.
English.
Okay, that's not a crime. I can't accept that. I can't accept that.
That's not my English.
It has nothing to do with the language. It's just, it doesn't fit the elements of the crime.
So that's my English.
And Yana, can I go into a breakout room with
Yeah.
Ms. Lou? And if I can go into if you're editing the documents, I can't.
Oh, sorry, I'll get out.
And Your Honor, I'm unable to change the language in the plea. And I think the appropriate remedy is to set this matter for trial. Ms. Lou has said that she doesn't want me as her attorney, but I don't have any conflict in this case. So I don't see any need to withdraw. There's no conflict.
Ms. Liu, why don't you want Mr. Ionati for your, Ms. Chenwell, are you there?
He likes argue. Non-stop argue with his expertise. He's a lawyer. I don't have no legal experience. I'm not good at English. So he is pushing me to do what I want. I don't want.
Well, we can certainly, Ms. Liu, we can certainly set this over and so that you can have the benefit of a Mandarin interpreter.
I don't need a Mandarin interpreter, but I don't have this lawyer. This lawyer is specifically bad.
And the issue, just so the court's aware, is that I can't.
He continuously likes to make me plead guilty.
I don't want you to.
Continuously likes to make me prolong the procedure. The longer, the better. That's what his intention.
He's trying really hard to get you through
No.
this plea.
He's trying hard to push me to do whatever I don't want. I just plead guilty. That's very easy. Plead guilty. Why
Ms.
he
Liu,
wants to plead not guilty, then he go for it.
Ms. Liu,
Not he's guilty. Now my business.
the problem is what you want to say is not a crime. So you can't plead guilty to something that isn't a crime. Mr. Ionati knows the elements of the crime, and he's trying to help you craft a statement that would fit the crime. He's trying to help you plead guilty. No attorney is going to write what you want because I won't accept it. No judge will.
So that's
It's not a crime. You have to have the elements of the crime. That's the way it works. We've had this same discussion, I think 9 times. Every time you plead guilty, we have this discussion.
What do you want? What do you want to put there?
That's not my job to tell you what to put there. It's only to say whether it's enough or not.
You don't accept it. Whatever you don't tell me what to do. Then what the heck?
I'm not telling you what to do. You want to plead guilty. You've told me that repeatedly. I'm trying to help you accomplish that.
Then what do you want?
What about an Alford plea? Have you discussed that with her?
I can try. I was asking about different ways of phrasing it, and it didn't work. I will try one more time, Your Honor.
Okay.
Wolf, you want to report?
Yes.
Okay. Go put your blanket back in bed.
Oh my God.
讲不清楚，你要什么也不讲。我说了我的，你又不干。
Officer, can you please join the breakout room? Thank you.
We're ready.
变态才是。
So, Ms. Lou, we've had a chance to talk. Is this a statement that I wrote, but you'd adopt as your own, that on February 18th, 2024 in SeaTac, Washington, at the SeaTac Airport, Port of Seattle, you knowingly entered the airport, it says without twice, without a ticket, and you had been trespassed from the airport?
Yes.
And how do you plead to the crime of criminal trespass in the first degree? We'd ask the court to accept the statement of defendant on plea of guilty.
I will accept the plea. I do believe it's knowingly, voluntarily, intelligently made, and there's a factual basis to support it.
All right.
Ms. Tenwiller, anything to add to the sentencing recommendation?
It's an agreed recommendation based upon defendant's history. Defendant has 39 days credit for time served.
Mr. Ainati, anything to add?
This is an agreed recommendation. Ms. Lou does get food stamps and is currently not working, so she's hoping the court doesn't impose any financial obligations.
Ms. Lou, is there anything you'd like to say?
Nothing to say.
I'm going to follow the agreed recommendation, impose a sentence of 180 days in jail with 39 days credit for time served, no fine. Jail time will be concurrent with any other holds, and the case will close upon completion of the jail time. Ms. Lou, I can't believe that you really enjoy spending time at SCORE. And we would be more than happy to help you find a job, find housing, find all sorts of alternatives. But it's got to be better than staying at SCORE. Sometime your attitude gets in the way of your best interest. All right, thank you.
Sanchez. Sanchez. Can you sit up, please?
What?
Can you sit up?
It's court, ma'am.
How can you sit up?
Good afternoon.
And this is Andrea Elizabeth Sanchez. You remember, Ms. Sanchez, we talked about you coming up to the seat up here for court.
Oh.
Ms. Sanchez, can you come a little closer? It's very hard to hear you.
I can't move. What do you want me to do?
This is 4A0259097. Is your true and correct name Andrea Elizabeth Sanchez? Could you speak up so we can hear you?
Yeah.
Okay, and your date of birth is February 18th, 1986. Earlier today, I went over your rights at arraignment with you. Did you have any questions about your rights I wasn't able to answer?
No.
Your Honor, I've gone over the charges, the maximum penalties, any mandatory minimum penalties, but acknowledge the complaint, wait for a reading, ask to plead not guilty, and we are asking for a direct appointment.
Plead not guilty will enter. I do find probable cause to detain. What is the city's, and I'm sorry, you asking for direct appointment?
Yes, Your Honor.
And I will direct appoint. What is the city's recommendation regarding release?
The city is requesting bail in the amount of 500 cash or bond, understanding that the defendant does not have a significant warrant or failure to appear history. Do note that the defendant was previously convicted of resisting arrest she did lie about her name in this incident. Therefore, we have the amended complaint today, adding the false statement.
Whoa, it's a miracle. I thought she couldn't move. She can now walk. God is good, y'all.
Charge. So did make it more difficult to identify the defendant. The city does believe there is a high risk of disruption administration of justice.
Ma'am,
And
can you
it was-
please get up? We're in court right now. I'm so sorry to interrupt you.
Obviously, the defendant's not being very cooperative now. We did have an indication from SCORE that she was uncooperative in booking and was set over from yesterday.
Any objection to those conditions?
Ms. Sanchez is hoping the court releases her. We are asked, she's no objection to the other conditions.
Ms. Sanchez, if I release you, will you come back to court? I'm sorry, what was that?
Yes.
Okay. I'm going to give you one chance to appear out of custody. Conditions of your release are that you attend all future court appearances, have no new criminal law violations, update your address with the court and DOL immediately if there are any changes, and no contact with SeaTac International Airport or the rental car facility except for valid travel purposes.
Why would you release that woman back to society on a PR bond? Why? She literally just yelled, lying sack of, at Prosecutor Weller. Oh my God, she's so disrespectful and defiant. And you're just going to go make her someone else's problem?
Your next hearing will be on April 16th at 8:30 in the morning.
Okay.
And that's an in-person hearing in SeaTac Municipal Court. You'll have to come to the courthouse for that hearing.
Okay.
If you don't, a warrant will likely issue.
Okay.
And SCORE will give you a copy of this order, but that's the only notice you'll receive.
Okay.
Do you still receive mail at the address on 133rd Street?
No.
Do you have an address?
I just don't know.
Okay, call the court immediately upon your release and let us know, okay?
Okay.
Okay, thank you.
Okay, Mr. Reedy, come on up, and then Ms. Rouser, Mr. Bush, Miss, I think it's this Quinn. On the record in Jonathan Reedy versus Sherry Rouser, Rick Bush, 2400482 LT. And you're Jonathan Reedy?
Yes.
All right. And then one of you must be Sherry Rouser. Okay. One of you must be Rick Bush. Yes? Y'all have to speak out loud because we're recording. And one of you must be Lisa Quinn. I'm Lisa Quinn. Okay, thank you. All right, so everybody's here. It's my understanding today that we're scheduled for a landlord-tenant hearing and that there's no agreement between the parties. I also see that this is a complaint to recover possession of the property, which means that this isn't about a financial issue at this moment. This is just landlord wants the property back. I do believe I also have in my file the lease. I'll look at the dates on this lease. Okay. So this is a month-to-month lease that started October 14th of 2023. Is that right? Oh, okay. Got that. And let's see if I can find the notice to quit in here. There's a label that makes it hard for me. So the notice to quit that said that Mr. Reedy wanted the property back by February 4th was served by personal service January 4th, 2024. Okay. So I have to determine if there's a triable issue. So let me ask, and I don't know which one of you has the most knowledge or feels most comfortable speaking on it, but you agree that this was a month-to-month lease? Yes. And you agree that you received the notice to quit that told you had 30 days to leave?
Yes.
Okay, so tell me what the dispute is today.
It wasn't, it says it was a month-to-month lease, but it wasn't a month-to-month lease, because we paid, like 8 months ahead of time. 8 months of, rent ahead of time.
So you
I got
pay,
paperwork right here to show what
Okay.
everything is.
so your position is you pay rent for 8 months at the front, at the beginning?
Right at the beginning, yeah.
Okay, you have to be a little louder, remember?
Yes, ma'am, yeah, at the beginning, I'm sorry.
So when you paid that, I'm looking at the lease and it was right at the beginning. That would have been October to November, November to December,
It's
December to
always-
January,
We paid rent all the way to April 14th.
January, February to March, March to April, April to,
April 14th is our last.
well, that's 6 months worth.
Oh, yeah.
Okay, so not 8 months worth.
Right, I'm sorry.
Okay.
I got everything right here on in writing if you wanna.
Well, what do you mean by that? I'm not gonna just take a stack of random papers, so tell me what the things are.
It's the lease that you wrote out for us.
So it's not the same lease he filed with the court?
No.
Okay, David, will you obtain what Mr. Browser says is a, I'm sorry, Mr. Bush says is a lease?
Yeah, that's what was written out by him to us. That was one of them. We had.
This looks more like a receipt.
That's, yeah, but that's for the lease kind of, it's all. And yeah, like if we leave before this time, he'll give us this much money back. If we leave before this time, we get this much money back. You know, kind of thing like that.
Well, this isn't a lease like you said it is, but let's see. So this says in the beginning, 4 months of rent was paid, which is different than what you just
Right.
said. And then,
It's kind of confusing the way it's.
then it says Lisa paid February to March.
It's all the way there, 14, March, whatever it is.
Well, who wrote this?
John did.
Well, when did he write this?
I'm not for sure the exact date when he wrote that, but it wasn't too long ago.
After you received the notice of termination of tenancy?
Yeah.
Did you pay him any money after receiving the notice of termination of tenancy?
No, we stopped after that because he wanted us to leave from without, because at first we thought we were gonna be there and we'd be safe, you know, we'd be secure in our living. And then we got a eviction notice the following day, so
Sure,
it's been pretty confusing.
sure. I just have to make some legal decisions. You did not pay any money after the day you received the notice he wanted to evict you. Okay. And in fact, this, what you,
We were already paid up, so, you know, we didn't have to.
Mr.
pay.
Bush.
Oh,
when I'm talking, you can't talk at the same
I'm
time.
sorry.
So you did it again, even while I'm talking to you, you did it. Okay. Is this just 2 copies of the exact same thing?
Yes.
Okay. Mr. Reedy, did you in fact accept an amount of rent that would have paid them at least, looks like through March, and then give them a notice to evict?
Actually, they are paid up until March 14th by the receipt here, which actually officially right now, that means they're behind 13 days. And my original notice to quit, complaint to recovery, does say in other, renovation of house and apartment number 3. The reason is because city code compliance says it's stated, if you have a rental, you have to have the houses up to city code compliance, you charge up to $500 per day per citation. Well, since this last month, there's been vandalism in their apartment somehow, which it's all relevant how it happened, but I had some other people tell me. And so they come by and be cited for that. So really officially, you know, things need to be done. So because the city says you have to do it or I'm cited, so I'm doing proper protocol. I gave them proper enough notice. I did say in the beginning when they paid me, I says, if you guys ever want to leave earlier, because you know, sooner or later, I'm gonna close down my business. I've had this for 50 years. I said, I'm done renting. I'm retired from the prison system. I just can't do it anymore. I says, but because of this, I can't take care of people breaking my houses. I had another house broken into a few days ago. It's a vacant one.
Mr. Reedy, focus.
But anyway, I'm sorry. So basically, they are paid up until March 14th. I need to renovate the property. So I'm asking them to.
Okay, but back to my original question.
Yes.
You accepted rent for all the way up till March 14 and then gave them an eviction notice.
No, leave it. No, I gave them. Well, whatever time I gave them their notice was.
January.
Yeah. Which means by the time you go in court, it'd be this time anyway, so.
Mr. Reedy, so you're avoiding my question, which makes me think the answer is yes.
Oh, I'm sorry.
Which is you accepted rent up through March 14th and then you gave them an eviction notice.
Correct. For renovation.
You didn't file a health hazard or anything like that. So there's there's no exigent circumstances here. You want them out, but the fact is you took rent and then you gave them an eviction notice that would have kicked them out during a time they'd already paid for.
They're not kicked out, they're there. And
Of course they are.
If they did, they would have got the money back as those statement there. So if you leave early before this.
Mr. Reedy, you're doing it again. Okay, so let's talk about the whole thing about the vandalism. So you heard a rumor that there's damage inside the property.
I got pictures, and I know I've been by, I got pictures too.
The property has not been cited by the city.
Not at the moment.
And these damages to the property are something that you don't believe that you can repair while they're occupants.
No,
Okay, why is that?
because I've never been a smoker, and a lot of people in the place there, they smoke, they have animals. I have allergies, I don't go in houses unless people are all gone. And I'm doing the whole house itself, so everybody in the whole apartments.
It sounds like you really shouldn't be a landlord. I kind of am really glad that you're retiring.
I will be leaving.
Okay.
So no, I can't do stuff myself, no. I take hire contractors.
Sure.
It takes them longer to come, but then I have to try to get an extension with the code compliance, which they don't like that. They want stuff.
But you haven't been cited by code compliance yet.
Not yet, but when they,
Okay, so you are hypothetically, in a hypothetical world, you might get cited by code compliance if you don't make repairs to the property that you're legally obligated to make as the landlord.
that's properly correct. I've been
Okay.
cited on all my properties before.
And so based on this hypothetical code compliance, legal, because you won't comply with your legal obligation to repair the property or gave them an eviction during a time period for which they've already paid rent.
I don't know what you mean by that. I gave them a notice because I need to renovate.
For a
the
period for
property.
which they'd already paid rent.
Okay,
So you accepted rent all the way up to March 14, and then in January, you give them a notice to quit that demands they leave in February. Based on damage to the property that you have a legal obligation to repair.
I guess I don't know what you mean by that. I gave them notice because I know I have to do repair because my 2 years extension is up this summer, so I need to do repair on it. I gave them plenty enough time.
Mr. Reedy, you have not offered me a reason why the repairs cannot be made while the premises is occupied.
I don't think he intentionally scammed them. I think he's just a bit doofy. He doesn't know the laws of being a landlord, and he's just winging it. You can't just wing it.
Other than you don't like it.
I don't go in when there's other people around there doing different type of things, for health reasons and COVID.
Yep.
I've never been a smoker, done.
You rent it to smokers, so
Yeah.
that is not a legal explanation. So what type of repair needs to be done?
Right now, a driveway window which goes in their bedroom that someone broke out. It's like a $400, probably $700 repair. Plus, as of a week and a half ago, somebody busted their entrance door in, broke the whole jamb off. And now they keep it closed with a knife at their property. For some reason, why, they're doing damage there. So there's more stuff on top of other things that have to do with the other properties. So really, it's not all focused on them. I want to start out in the basement because, well, actually today, I gotta be there between 4 and 6 and 4 wire light has to replace a new meter. Because they cited me for not getting back to them in time. They gotta be there and put a new meter in, so. So because I'm closing down my properties, I gave everybody notice to quit for renovations. I'm closing down all my properties I had for years. So it has nothing to do with, all my tenants have been good, they've all paid. I've worked out with them, but, I can't I need to retire again, not be around, the city and work on repairs. I haven't worked on a house in a year and I got health issues. I can't work on nothing.
You're absolutely fine to retire, Mr. Reedy, but what you can't do is take a bunch of future rent from a tenant and then evict them during the period they've already paid for.
Okay, but they're not gone. You see, I guess,
See, but when I start measuring whether they have paid for the period that you're evicting them, it starts with the notice to quit. So you gave them a notice to quit in January, they were paid all the way up to March 14th. So they may be delinquent on their rent today, but when I have to consider whether you properly gave them a notice to quit and you're offering no particular reason for backing out of the rent you already accepted, I'm measuring from the day you gave them the notice to quit. You said there needs to be repairs to the property. You haven't attributed or blamed them for the damage.
no.
And also the repairs that need to be done, you have an obligation to repair as the landlord. And it is not a basis to evict them. It is not a basis to evict a tenant because something needs to be fixed at the property, especially something that they didn't do.
Well, I understand what you're saying there, but when I have contractors come in, they leave usually some of the jobs they do because they're doing the whole house, not just their apartment only. They want to use a basement as a secure area because it's out back. It's in the basement, it's secure, and put all their equipment there. So nobody can be there, starting there before they do my other three. It's like a 12-unit apartment. So they want to have all their stuff there. So they just don't want to come back and forth because there's a lot of crime around the area. So they want to make sure it's secured because they want to put a camera system up there to make sure they're watching this time, make sure nobody's going to break into the place while all their expensive equipment's there, while they're renovating the house so I can sell it.
Mhm.
So it's a safety factor for the
That
contractors.
has nothing to do with the tenant. None of that is their problem. None of that is a basis to throw them out of the place they already paid for. I'm not saying you can't give them a notice to quit today, because obviously they have not paid for a future period of rent at this moment. You could give them a notice to quit today and file an eviction. It's a month-to-month tenancy. But on January 6th, they had already paid you up to March 14th. And so you can't then, without any good reason, just evict them for a period of time that they've already paid for.
Oh, so you're saying, okay, I kind of see what you're saying. So you're saying, if I gave them a notice, it should be at like March 14th.
Or you could have gave them notice February 15th, that they had to be out by March 14th, because that's when the money was done for. You know what I mean?
Oh, so it sounds like they did it a month before or something?
You did it too soon because they had already paid you. So if you had
I
done
didn't
it,
know that had anything to do with it. I knew it'd take 2-3 months to get there, and I had to get in there.
I
and
hear
get some
you.
contractors in there, so I didn't know, which is still, it's not my fault, but I understand your point now that you're saying, oh,
right,
so
so,
if they're paid up, you can't give them one until then.
right, you could have gave them a notice to quit like February 15th that said you need to be out March 14th, because that would have been 30 days notice that when the rent that they'd already paid was done, they were done. See?
Yeah.
But you gave it to them way back like January 6th and said they needed to be out by February 6th. They had already paid you for a
Yes, but I did it, as Rick knows, he's worked with me in my house, they're all good people. I said, we got to give you a notice ahead of time, because we're renovating these houses, and it might take a while to do. He said, yeah, it's fine. I says, if you can get out before that, and I even told them, I said, I'll give you proration money back, I'll help you move, not a problem, as Rick does stated that to you in the moment. So no problem. So I gave him a couple of notices before, but I said, understand your point there, you should be until March, I get their money, and I'm thinking, okay, I'm sorry, didn't know that, but I was willing, as he just stated. I said, even when they moved in there 4 months back, they paid me 4 months ahead. I said, if you're here, because they came from Florida, I says, if you don't like it and you want to leave, let me know, and I'll give you money back. They said, okay. I said, so I'll give them all the time before, because I knew this summer I was gonna be doing renovations. So I mean, I can see a little mistake I thought, which I didn't think that was a thing there. I'm just going by the city says you got that done. COVID's over with. The inspectors are out there for summertime. They want the stuff done. And I like my inspectors are all good with it. They usually give me extensions, but they know, John, you just can't do it anymore. I said, I know it. I mean, it's just overwhelming that, I had another house broken last week, and they right across from there, and they stole all my stuff. And it's all red tag, and they broke in and stole all my wiring. It's overwhelming because everybody's just see something vacant they want to take from you. And I've been in corrections for years, like, why? I help people out, and I just still get, but.
So here's the deal. I cannot grant you an eviction today, but I want to talk to the tenants for a second about this, because I think you understand that if an eviction occurs, that can affect your ability to rent somewhere else. It is clear that Mr. Reedy does not want to rent to you anymore because he sounds like he really just doesn't want to be a landlord, but who knows? He can end your tenancy for any reason at all, really, as long as it's a legal reason. So he could give you a new notice to quit tonight, and we could be back here shortly. If you don't want an eviction on your record, you should consider your options for a new place, because he didn't do it completely correctly this time. But he won't make that mistake again. And you don't want to have issues getting a new place. So take this time to look for something suitable for you before you have to go through a court and risk a judgment and all of that.
I've been looking really hard for Section 8 and stuff like that, foreign fixed income. So it's kind of hard to find a place that it is, but we are willing to do that.
Okay.
Eventually.
Well, you don't have a lot of time because Mr. Reedy has made it quite clear. He is done. He's done. So I'm going to dismiss the case or find there's in favor of the defendant for today. Like I said, that doesn't mean he doesn't get home tonight, show up with a new notice to quit, and tell you you have 30 days from today to find a place to avoid court proceedings. Okay? Do you have questions about that? Mr. Reedy, do you have a question?
Oh, yeah, I do have a question about that. I have another question of something I'm not about what you just stated. I know when we were here about 3 weeks ago, you looked at them and says, do you need any more time for some assistance? And they said, yes. So I'm assuming that the 3 weeks that they had was time for them to try to get focused and do what they had to do to get help. Okay, now we're going on another month. So there's another two and a half months of staying in my house.
It's however long it takes because you didn't do this correctly. So you have to start again. The law is very clear about certain things. And one of them is if you're doing a termination of tenancy, you can't accept rent for a period that you're kicking them out for. So by taking all this rent at the front, unless they did something to you, the property or some good reason, you had accepted rent for that period. So I don't believe you can kick them out.
Okay, when you said they did something to the property,
Right, so if
I
you-
can't prove that.
Well,
But I know, so it's like, it's a catch-22.
Well,
I
sometimes-
lose either way.
well,
I mean,
the solution would have been to have filed the notice to quit when they were in their last 30 days that they'd paid for. That would have been the solution.
so even, first of all, I appreciate your professionalism telling me that. I was polite enough to tell them I need to renovate, and that's why I'm giving this.
I understand.
So even though I did the proper protocol, I've given 3 or 4 months back, and I just filed that in there. I mean, I can still see your point with what you're saying. I don't feel as though it's wrong what I did because I gave them plenty enough time, and it came out about the right time, so I assume the time limit would be the same thing, so we start renovating. Not to wait for another month, so if the city comes in or happens to do a drive-by, I say, oh, your window's there, I'm a red tag you.
Well,
And
you
I'm
do-
cited then. Just kind of catch-22.
Well, you have an obligation as a landlord to fix the property.
So pretty much I can give them another notice to quit. It has to be 30 days, it can't be a 10-day.
Well, if you do the short one, the 7-day, that would be for non-payment. And that would give them an opportunity to pay the missing rent and continue the tenancy. If that's not what you want, you have to do the longer version. If you're trying to end this tenancy, even if they're able to pay rent, you have to do the long one.
Yeah, so bottom line, either way, I did, like you said, if I did the 7-day or 10-day, and then if they pay, they can stay. But since I'm closing out my properties, it's best just to do, I assume.
Right,
the
so-
30-day, so I have closure, that way I can get in there and tell my contractors to get in there in about 30 days, plus a 10-day writ, so another 42, 44 days,
Well,
give or take.
It's my hope that the tenants try to leave before you start another court proceeding. 'Cause
That
they
would be good
don't-
on their record.
Because they don't want the eviction on their record.
Right.
They want to be able to find a new place.
Yeah.
If they have to tell the next landlord that they've been evicted before, that would hurt their chances. So I'm guessing they want to do this before it gets to that point.
Yeah, you understand, thanks, and right, yeah.
Oh, okay.
Because I'll still give you a good reference, as you know, when you go somewhere, but best if you try to find a place before then. I'll still give you guys a notice. That's what I gotta do. So that's okay. So I just want to let you guys know, I can help you out.
Okay,
Thank
so let's see if I can create a judgment that reflects my ruling today and get this all squared away. And then we'll move on with moving forward. David, you can give these notes back to the tenant. Onto them. Great, that's for judgment from today, and we start anew. All right, this is Michigan Home Rehab LLC versus Nakia Williams.
Yes.
2400451 LT.
Good afternoon, Your Honor. Robert Acton, the attorney for the plaintiff.
Okay. And you are Nakia Williams?
Yes.
Okay. Today is the date for a landlord-tenant hearing, and it's my understanding the parties have not reached an agreement. This is a non-payment of rent case with a money judgment on it. So I have to determine if there's a triable issue before we begin. Mr. Aknicki, did you meet with Ms. Williams today in an attempt to discuss what amount of rent you're claiming is owed?
I met with Ms. Williams. In this particular case, when we filed the complaint, my client had $994 that they believe was owed in rent. We filed the complaint on January 18th. On January 19th, Ms. Williams paid $900. My clients were not willing to waive the court costs that were associated with this. So all we're seeking today is $223 in court costs. I explained it to Ms. Williams and she does not want to pay that. So that's where we're at.
Okay. Well, tell me, Ms. Williams, why do you not believe you have to pay the court costs?
Because when I came in to pay, I had been in correspondence with them, letting them know what my situation was and why I couldn't get to office. It wasn't because I didn't have the money. It was because I couldn't physically get to the office to be able to pay.
Is that the only way to pay?
Yes, on time. I mean, to be able, or it has to go through mail. They have a PO box that I've never used. I've been in this house for 5 years. I've always.
So there's
went
mail.
into the office.
There's in person. Any other ways that
No.
they accept payment?
No.
Okay. And so you chose not to mail it to them. And then how late did you become?
So I have a grace period. It's due on the 1st. I have a grace period that's stated in my lease that I have to the 5th. And I was late and I paid the late fee on the 19th as well. The reason why they only got the 900, because when we had the pre-trial, they had me down that I still owed them $90, which was an incident where I had to come out of pocket and pay for plumbing because it was during the holidays and I couldn't get in touch with the maintenance, the office, everything was closed down. So I paid $150 out of pocket.
For the plumber?
For the plumber, yes. I provided them with a receipt to let them know that I paid that. I deducted that from the January's rent. And they didn't want to compensate me at the time for the service. And so we were in dispute about that. And so I continued to come in and pay my rent. So after this incident happened, I was in correspondence with them because I was having some health issues and I was in the hospital. And I have my phone turned off right now because I didn't know if I could have it on during the proceedings in the courtroom. But I do have evidence in my phone of me being in.
No. I told you during the pretrial, anything in your phone needs to be printed out and brought to court because I don't take phones during hearing.
Right.
So you're allowed to have your phone and you can have it on. You just can't give me your phone because I don't want to see anybody's phone.
Okay.
If I have to take your phone, I have to put an exhibit sticker on it and call everything in it an exhibit, and I don't want to do that. That's too much.
Okay.
Okay, but back to the January payment. You said you paid a late fee. How much of a late fee did you pay?
$50.
A $50 late fee. Okay.
So I just only retracted the $150 that I paid in the plumbing for the service.
Okay. So they said you owed 90 and they took that off. And then you said there was $60 left towards the plumber.
I paid $150, but I gave them my rent is originally $995.
Okay.
I gave them $900.
Okay. So you took 95 off, so they still owed you like another 55 towards the plumber.
Correct.
That's your position, or that they owe you $55 for the plumber?
No, I don't want to owe nothing.
Well, if I can take it off the court costs, maybe if they owe it to you.
That'll be great.
Well, that's why I'm asking you the question, and I'm also asking you about your late fee. Okay. Okay, so then after January, did you still live there?
I did. I came in, my rent has been on time.
You paid February?
This was the only, January was the only payment that had been late ever since last year. And so and like I said, because I've been in this house for 5 years, I didn't expect them to take me to court.
Mr. Aknicki, unless you're looking up something related to this case, put your phone away.
I'm looking up something related to this case. I'm looking up the ledger.
So for 19 days, they submitted for me to come to court. I wasn't even 30 days behind.
Let me ask you this question though. January 3rd, they served you with the demand that said you had 7 days to pay. Do you remember that?
Yes.
Okay. And they said they mailed it to you. So you probably received it sometime after that day.
Correct.
Okay. And so receiving that demand to pay didn't get you like in the idea, like, if I don't pay this, I'm going to court?
No, I mean, I understand that. I do understand that.
Okay.
But I've never been taken to court for not being unpaid for 19 days.
It doesn't matter. They can take you to court for being unpaid. You know, if they give you the 7-day notice and you don't pay, then if you're 7 days late, they can take you to court. So that's not really a defense to the paying of the court costs. They have to file a court proceeding to get your attention.
But here's the thing, that's what I'm saying. I've been in this house for 5 years. They don't have to send a court notice for me to pay rent, especially even after the fact. You think I came in February, pay my rent on time, came in on March to pay my rent on time, to be taken to court because I paid my rent late, you know, 19 days.
Because you
But I've
can't.
been consistent though. And what I'm saying is, as far as for the landlord and the tenant relationship, obviously it's broken somewhere, right? Because he could have talked to me, just like when I tried to discuss with him several times about my $150. You think I wanted to pay $150 out of pocket that he kept trying to tell me he wasn't going to compensate me for? They didn't drop it until I decided that I was going to pursue and go through with the pretrial. I was going to come to court and I was going to speak my piece. And they didn't drop and say, oh, we'll forgive, we'll waive. When I was trying to discuss this with them back in January, they didn't want to talk to me about it. You know, but here, you steady taking my rent money. You steady taking every time I come in here, everything is okay. They could have been dismissed this. We could have settled this out. I've been a tenant, like I said, for 5 years. I always had issues with the landlord when it came to fixing something in the property. And we always have an issue with that.
Is there anything broken right now?
The city came just on February 26th to do their 3-year inspection.
Sure.
And so
Answer my question. Is there anything broken right now?
Yes, ma'am.
Okay, could you answer that?
Yeah.
Okay, what's broken?
Yeah, the faucet.
Which faucet? Bathroom, kitchen?
The kitchen.
What's wrong with it?
It's leaking.
Like it drips or underneath?
Yes, it drips.
Oh.
And it's starting to get clogged.
Clogged, what do you mean?
Like the water is receding, it's going up and then it's taking a long time to go down.
Okay.
Also, there were some other things in the basement. There was some electrical outlets. You know, I take very good care of the home. I do everything in the house. The house is basically like I own it, except I just pay rent. I do everything. I do the lawn care.
Okay.
I do the snow removal.
Madam,
I do
focus on the
everything.
question I asked you and answer my question. Tell me what's broken in the house.
Yes, and then so the electrical, and I just had to have electrical person come out and put in another electrical fuse in the box or something, because I just got a washer and dryer, and the dryer was not working. It's because it didn't have any power. So at some point the power was disconnected, and so I called an electrician to fix it, which I also paid out of pocket, but that was okay.
Did you notify your landlord that that needed to be done?
No.
Why not?
Because he takes forever to do repairs. That's my issue.
Well, you can't complain about it if you don't complain about it.
It happened, I had to pay plumbing. I notified them 3 weeks in advance.
Okay.
Things don't get done in a timely manner, and when I do, I'm always like, okay, you know, because I understand every time he gets somebody, they quit. He can't get nobody reliable. So I try to be empathetic and think, you know, okay, I always give them an olive branch, but you can't give me one. So I'm just.
Okay, you've digressed again. Ms. Williams, is there anything else that's not properly repaired in the property besides the dripping kitchen faucet, which you said also has a slow drain, although those are easy fixes. And then you said you decided to get the electrical breaker fixed for your dryer. Anything else?
No.
Okay. So just that thing.
Yes. Oh, can I just add one more other thing? But I did not say with the city, but it is an older house. You know, the house is like 1920 something. So a lot of the things in there are grandfathered in on the city code. But one of the things I noticed is that where the sink area is separating from the wall. The drawers, like the handles, are again dry rotted. So
Did you put in a complaint to your landlord?
I did not.
Okay, so to the extent that any failure to repair would isolate you from expenses, you have to make a documented request for repair. So you can't like sit back, be upset about things that aren't fixed, and then when they bring you to court for something, then say, I have all these complaints. You have to make those complaints to them and give them an opportunity to repair them.
I do that now.
Except I just asked you about specific ones and you said you did not, and you had reasons. And I'm telling you that those reasons aren't going to work. You either have to make the complaints or you don't get to use them against them in court. Okay. Mr. Oknicki, before I tell you what I'd like to do, did you want to respond to the issue about the plumbing?
The plumbing, as far as the plumbing issue is concerned, I know that based on what Ms. Williams originally did by taking some money off her rent, my clients originally filed a complaint for $994. By the time it came to the pretrial, only $94 was due. My clients have waived that, so they're not even seeking that any longer. So I don't know anything about the extra $50 she's paid, I guess, for plumbing. I wasn't aware of that.
She said she paid $150 and she took $95 off her rent.
I have the receipts.
Yeah, I mean, she has a receipt if you want to look at it.
So you took, I guess I would just ask Ms. Williams what months she took off, what,
January.
She said she took $95 off of January.
$95 off of January.
Which
Okay.
is how apparently it ended up that she only owed, did you say 94, she said 95.
So this is my receipt for 900 that they gave me. And then this is for the repair.
So I guess all I would say, Your Honor, is that the total court costs are $223.04.
I get $219.04. Where do you get $223.04?
I had a 110
filing fee, $34.04 service.
3404 service.
That's what it says.
If I
Go on
did
that microphone there.
110 plus 75 statutory attorney fee plus the service you had, Your Honor, was 3404.
Yes.
Michigan math.
Okay. Then I have 219.4 for court costs.
That's what I had.
If the court, I'll leave it at the court's discretion as far as the other
Yeah.
50 something that she paid.
Ms. Williams, I don't want to enter a judgment against you today because that could have other impacts on your rental history, etc. But the fact of the matter is that you were 19 days late, and so you owe them something. I'm going to take $50 or $55 off for the plumber. And I'm going to take $10 off because I find their late fee to be in excess of what I approve here at the court. That means you owe him $154. Is that something you can pay today so I don't have to render a judgment?
I only pay until Friday. So like 2 days.
I really didn't want to do it.
Your Honor, if Ms. Williams wants to agree on that 154, I could do a conditional dismissal instead. I don't have any problem with that.
Where they dismiss if you pay them $154.
Yes, Your Honor.
You want to do that? Okay. All right, I'll let you to complete that document and then come let me know when you're done.
Thank you.
Thank you.
Well, that didn't work out too bad for her in the end. She got reimbursed the plumber costs. I think the calling the electrician to have the electrical updated so that she could have her dryer, I think that should have been on her anyways, because I don't think it was anything wrong with the electricity necessarily. She just needed an additional type of outlet or something added to the fuse box for it or something, but a nice wholesome ending. Oh, guys, thanks so much for coming out. I really appreciate everybody. I had so much fun tonight. It was nice to finally have some actual court to run. Yeah. I'll have to continue looking back through the archive drive. Thank you guys so much. I love every one of you. Be safe, be well, sleep sweet, and much love.